We are less than 24 hours away from a moment that could fundamentally rewrite the boundaries of American power. Tomorrow morning, at exactly 10 a.m. Eastern Time, the United States Supreme Court is set to release a series of opinions that may very well deliver a shattering blow to the concept of the Imperial Presidency. You are not imagining the tension in Washington right now. It is palpable. We are watching a constitutional stress test in real time, where the highest court in the land is forced to decide, does the President of the United States have the inherent authority to act as a one-man legislature, or are there still lines that even the Commander-in-Chief cannot cross? The case at the center of this storm involves Donald Trump's aggressive use of the International Economic Emergency Powers Act, or IEEPA, to impose sweeping tariffs on over 200 countries for an indefinite period of time. To be clear, this isn't just a political debate about trade war or protectionism. This is a fundamental battle between Article 1 and Article 2 of the Constitution. Under Article 1, the power to tax, to regulate foreign commerce, and to control the nation's purse belongs exclusively to Congress. Trump's legal team argues that Congress delegated this power away during emergencies. However, the question the justices are grappling with is whether an emergency can be used as a permanent bypass to the democratic process. As a legal analyst with decades of experience observing these power shifts, I can tell you that the signals coming from the court are unprecedented. Even the most conservative Trump-appointed justices, men like Gorsuch and Kavanaugh, sounded deeply skeptical during oral arguments. They didn't just ask tough questions, they challenged the very logic that a president can sign a law giving himself more power and then effectively veto any attempt by Congress to take it back. When you hear Justice Gorsuch talking about a serious retrieval problem, you know the administration is on thin ice. But perhaps the most telling evidence that a smash is coming isn't found in a courtroom, but in the silent preparations of the bureaucracy. The Customs and Border Protection Agency, the CBP, has quietly established electronic mechanisms to refund billions of dollars in tariffs. They aren't issuing paper buy checks anymore, they are building a digital pipeline to return $150 billion to the private sector. This is the behavior of an administration that has seen the writing on the wall. They are bracing for a loss that would not only gut Trump's economic strategy, but also reaffirm that the president is a servant of the law, not its master. Now let's look at why this specific legal battlefield is so dangerous for the executive branch. The core argument the Trump administration is leaning on is that Congress can delegate its authority to the president under the International Economic Emergency Powers Act. However, as the oral arguments revealed, the justices are starting to see this not as a partnership between branches, but as a permanent power grab that Congress can never truly undo. Justice Neil Gorsuch, typically a defender of executive strength, hit the nail on the head when he pointed out a serious retrieval problem during the proceedings. Gorsuch's concern is a technical but lethal one for the administration's case. He noted that once Congress delegates power by a bare majority, and the president signs that delegation into law, Congress essentially loses that authority forever. Why? Because no president is ever going to sign a new law that strips them of their own power. To get that power back, Congress would need a veto-proof supermajority, which is a nearly impossible threshold in today's polarized environment. This creates a one-way ratchet where the executive branch grows larger and Article 1, the power of the people through Congress, withers away. This isn't just a theoretical debate about the Constitution, it's a direct challenge to how Trump has stretched the definition of an emergency. The administration has attempted to use emergency declarations to impose tariffs on an indefinite list of goods from hundreds of countries for an indefinite period. But even the conservative justices are showing that they are on a losing streak with these broad interpretations. When you have Kavanaugh or Gorsuch, judges who are historically pro-presidential power, speaking about these issues in negative terms, it signals a massive shift in the judicial winds. Furthermore, Justice Amy Coney Barrett's line of questioning was particularly telling because she moved past the if and started focusing on the how of a government defeat. She pressed advocates on the logistics of a reimbursement process, explicitly asking if it would be a complete mess. This indicates that the court is already contemplating the post-ruling reality, a world where the federal government might have to return upwards of $150 billion in collected tariffs. While the advocates admitted there is no class action currently in place, they acknowledged that specialized trade law procedures would be required to handle the inevitable flood of administrative protests and refund claims. By framing this as a major question of vast economic significance, the Supreme Court is positioning itself to smash the Imperial Presidency and return the power of the purse to where the founders originally intended, the halls of Congress. In the corridors of power, money doesn't just talk, it screams. Right now, the staggering figure of $150 billion is causing a collective intake of breath across Washington's financial landscape. We are no longer just discussing a theoretical constitutional debate in the ivory tower of the Supreme Court. We are witnessing the construction of a massive refund machine that threatens to dismantle one of the most significant pillars of Donald Trump's economic legacy. Consider the diagnostic question posed by Justice Amy Coney Barrett during the heat of oral arguments. She didn't ask if the tariffs were popular. She went straight to the logistics of the aftermath, asking, "If you win, tell me how the reimbursement process would work. Would it be a complete mess?" This isn't a casual inquiry. When a Supreme Court justice starts asking about how to give the money back, it signals that the court has already identified a constitutional defect that they are unwilling to ignore. The government's advocates tried to play down the difficulty, but the reality is clear. A $150 billion refund wave is looming over the horizon. The legal threshold here is unforgiving. As referenced in the McCassin case of 1990, the court has previously held that serious economic dislocation is not a valid reason to uphold an unconstitutional act. In other words, if the president overstepped his Article 2 boundaries to seize Article 1 powers from Congress, the messiness of the refund is legally irrelevant. The Constitution takes precedence over the balance sheet. But here is the real bombshell that suggests the administration sees the writing on the wall. While the public remains focused on the headlines, the bureaucracy is moving in the shadows. The Customs and Border Protection Agency, CBP, has quietly established electronic mechanisms to refund these billions. They have moved away from the era of slow paper checks and are instead building a digital pipeline capable of wiring $150 billion back into the private sector at the click of a button. This quiet preparation by the CBP is a silent admission of defeat. It suggests that the administration's own legal team understands they are on a losing streak at the Supreme Court. To build a refund infrastructure of this scale, right before a major ruling, is the behavior of an executive branch that is bracing for a smash. If SCOTUS rules that these tariffs were a violation of the separation of powers, this $150 billion digital pipeline will become the delivery system for a historic judicial correction of executive overreach. While the world is fixated on the hundreds of billions of dollars at stake in the tariff battle, there is another ticking time bomb at the Supreme Court that could fundamentally silence the voices of millions. Tomorrow morning's opinion drop isn't just about trade. It's about the very survival of American democracy as we've known it for the last 60 years. The case is Callais versus United States, a redistricting fight out of Louisiana that threatens to hammer the final nail into the coffin of the Voting Rights Act. If the tariffs represent a smash to the president's economic power, the Callais decision could be a smash to the representative power of black and brown communities across the nation. The legal paradox at the heart of this case is almost too ironic to believe. The Supreme Court is being asked to determine if congressional districts drawn to ensure fair minority representation are, in fact, a violation of the 14th Amendment. Remember, the 14th Amendment was drafted specifically after the Civil War to empower newly freed slaves and guarantee equal protection. Now, we are seeing a radical reinterpretation where the court might argue that colorblind redistricting must take precedence, even if it results in the erasure of minority voices. Adam Johnson warns that we are in serious trouble because the court's framing suggests that reflecting the true demographics of a state could somehow be viewed as unconstitutional. What makes this even more chilling for advocates of the Voting Rights Act is the sudden and sharp shift in the court's moderate conservative bloc. Chief Justice John Roberts and Justice Brett Kavanaugh were once seen as the last remaining vestige of support for the Voting Rights Act within the conservative majority. They previously opposed the complete dismantling of these protections. However, during the most recent oral arguments, their tone changed dramatically. They appeared highly supportive of finding a legal pathway to effectively nullify the Act's influence. If the court rules as expected tomorrow, they will essentially be declaring that the era of protected minority representation is over. This isn't just a win for a specific political party. It is a seismic shift in how power is allocated in the United States. It means that the lily-white districts Popak describes could become the new standard, leaving minority demographics without a seat at the table. Between the tariff refunds and the redistricting fallout, tomorrow morning at 10 a.m. will be remembered as the moment the Supreme Court didn't just interpret the law, it dismantled the pillars of the existing order. In the age of viral headlines and instant speculation, it is easy to get lost in the noise of what might happen. As we wait for the 10 a.m. opinion drop tomorrow, social media is already buzzing with rumors that the Supreme Court is about to strike down birthright citizenship. Let me clear that up right now. It is not happening tomorrow. Birthright citizenship, while a massive focus of the Trump administration's immigration agenda, has not been fully briefed or argued before the court yet. It remains a looming legal storm for later in 2026, but tomorrow's decisions are strictly focused on the immediate constitutional crises of tariffs and voting rights. However, do not mistake the absence of a birthright ruling for a lack of activity. While we wait for tomorrow's opinions, the court is already in the middle of a historic January session. In fact, as we speak today, January 9th, oral arguments are taking place in the landmark transgender rights hearing, U.S. v. Scrimeti, challenging bans on medical treatments for transgender youth. This case will serve as a pivotal test for the Equal Protection Clause, and its outcome will define civil rights boundaries for a new generation. But the date you really need to circle on your calendar is January 21st. This is when the Supreme Court will hear the case of Lisa Cook, the Federal Reserve Governor whom Donald Trump is desperately trying to purge from the Board of Governors. This isn't just a personnel dispute, it is a battle for the very soul of the American economy. Trump has leveled allegations of mortgage fraud against Cook in an attempt to fire her for cause. But legal experts and former Fed chairs argue this is a pretextual move to undermine the independence of the nation's central bank. The stakes here could not be higher. If the Supreme Court allows a president to fire an independent Fed governor based on unproven allegations, the firewall separating political cycles from the stability of the U.S. dollar will be breached. The question the justices must answer is whether the Federal Reserve is special enough to remain shielded from political interference. We will be live streaming those arguments to analyze whether the court will protect the Fed's autonomy or allow the presidency to consume yet another independent institution. Between the potential tariff smash tomorrow and the Fed purge arguments in 2 weeks, January 2026 is shaping up to be the most consequential month in judicial history. The battle we are witnessing tomorrow at 10 a.m. is about far more than just a single president or a specific set of trade taxes. It is a trial of the Imperial Presidency itself. For decades, power has been leaking out of the halls of Congress and flooding into the Oval Office, creating a version of the American government that the Founding Fathers would barely recognize. When the Supreme Court decides whether to smash these tariff powers, they are essentially deciding if the United States remains a representative democracy or if it has permanently shifted into an executive autocracy where the president can single-handedly disrupt global markets under the guise of an emergency. This isn't just an American problem, it is a global one. The transcript makes it clear the guy in the Oval Office is going global, and therefore, the legal resistance must go global as well. Our allies, from the UK and the EU to Canada and the Five Eyes intelligence community, are watching these proceedings with bated breath. They are looking for a sign that the American system still has functioning checks and balances. If the court allows the president to unilaterally impose tariffs on 200 countries indefinitely, it signals to the world that American trade policy is no longer based on treaties or laws, but on the shifting whims of one individual. This uncertainty is what collapses alliances and destabilizes the Western order. Even the MAGA judges on the bench seem to realize the gravity of this moment. As Adam Johnson pointed out, you have to be a fool to ignore the negative tone Kavanaugh and Gorsuch took during arguments. These are justices who generally favor a strong executive, yet they are recoiling at the idea of a presidency that can sign its own power grabs into law and then veto any attempt to take them back. They are staring into the abyss of a retrieval problem where Article 1 becomes a ghost of its former self. The stakes for the average citizen are just as high. This is about your job, your cost of living, and whether your vote for a representative actually carries any weight in how the country is run. If the Supreme Court guts these powers tomorrow, it won't just be a win for the plaintiffs. It will be a historic reassertion of the rule of law over the rule of man. We are at a crossroads where the court must decide. Is the president a partner in government, or is he a king in all but name? Tomorrow at 10 a.m., the global verdict arrives. They want you to feel small. They want you to believe that the $150 billion trade wars, the complex IEEPA statutes, and the dismantling of the Voting Rights Act are technical legal issues far beyond your reach. They want you to stay quiet as power is shuffled between marble pillars in Washington, assuming you won't notice when Article 1 is stripped of its authority. But here is the bombshell they don't want you to understand. The final check on a rogue executive isn't just a gavel in the hands of a Supreme Court justice. It is the power of an informed and organized citizenry. It is what we call people power. And in 2026, it is the only force capable of sustaining a democracy under fire. The reason we are expanding our reach, going from a YouTube channel to a full-blown global podcast network on Apple and Spotify, is because the stakes have never been higher. As the guy in the Oval Office goes global, using his Article 2 powers to disrupt international commerce and rewrite domestic election laws, our defense of the Constitution must also go global. This isn't just about reporting the news, it's about creating an ecosystem where the law is deconstructed, decoded, and returned to its rightful owners, you. This is why we are bringing in heavy hitters like Sidney Blumenthal and Sean Wentz for the court of history, to show you that what is happening today isn't an accident. It is a calculated attempt to rewrite the American experiment. When we talk about Justice Gorsuch's retrieval problem or the mess of a $150 billion refund, we are really talking about the loss of public control over the government. If the president can delegate power to himself and then veto any attempt by the people's representatives to take it back, the democratic experiment is effectively over. This is why your support, your citizen power, is not just a slogan. It is the fuel for the resistance. We are also seeing this fight for justice extend beyond the courtroom. Adam Johnson's launch of the Popak firm is a prime example of turning people power into legal action. It is about obtaining justice for those injured by life-altering events caused by heartless corporations and government entities. It reminds us that whether it's a catastrophic accident or a constitutional violation, the fight for accountability is universal. Tomorrow morning at 10 a.m., when those opinions drop, we won't just be spectators. We will be exercising the very people power that the executive branch has tried so hard to silence. We are going big time in 2026 because the crisis has gone big time, and the only way to meet it is together. The clock in the Supreme Court's Great Hall is ticking toward 10 a.m. As we stand on the precipice of this historic opinion drop, we have to recognize that the era of Mr. Tariff is facing its ultimate legal reckoning. This isn't just about trade policy anymore. It is about whether the judiciary will finally step in to smash the unchecked expansion of executive power that has defined this administration. We've already seen a major signal earlier this week. In a stunning 6-3 vote, the court upheld a stay blocking the administration from federalizing the National Guard in Chicago, citing that the president failed to meet the strict legal conditions of the statute. If the court applied that same level of statutory originalism to the International Economic Emergency Powers Act, IEEPA, then Donald Trump's tariff empire is about to crumble. The lower courts have already spoken. IEEPA does not mention tariffs, and no president in history has ever used it this way until now. If SCOTUS follows suit tomorrow, it will trigger the largest financial reliquidation in American history, a digital wave of $150 billion flowing back from the Treasury to the people. But as we watch the 10 a.m. drop, don't just look at the money, look at the soul of the government. Will the court protect the Voting Rights Act in the Callais case, or will they allow the 14th Amendment to be used as a weapon against the very people it was meant to empower? Will they protect the independence of the Federal Reserve when we return for the Lisa Cook arguments on January 21st? Or will the central bank become another wing of the White House? We are at a turning point where the law must either be a shield for the citizen or a rubber stamp for the sovereign. The opinions are coming. The Constitution is waiting. And tomorrow, we find out if the Imperial Presidency finally meets its match. I'm Adam Johnson, and this has been a special alert. We will see you